And this matter is before the court today on the plaintiff's motion to file an amended complaint. I would invite counsel to place your appearances on the record.
Steve Grimm and Ben Grover for the plaintiff.
Thank you.
Sam Gilbertson on behalf of defendant John Tetzlaff.
Very good. Thank you, Mr. Gilbertson. And Mr. Grimm, this is your motion, and Mr. Gilbertson argues that I should deny it because obviously I still have an opinion and order due out on the his motion to dismiss based on the arbitration clause. What's your argument that shouldn't be subsumed by that?
Well, yeah, he's wrong because this the proposed amended complaint adds the LLC as a party plaintiff and adds a new defendant who received converted money. This is a derivative action brought by the LLC. It is not a member dispute. So therefore, the operating agreement has no bearing. The provision that 12.1 that we discussed earlier has no bearing on this complaint. We had to wait until now to file this complaint because MCL 450.4510 required us to give 90 days notice to Mr. Tetzlaff, which we did, not only to him, but to his counsel more than 90 days ago. If we could have filed on behalf of the corporation earlier, we would have, but we are required by statute to give them the 90 days notice. The argument that this motion should be denied is without merit. If the factual determination establishes that the complaint was filed to harass Liberty Tetzlaff, well, I am sure the court, after a factual development, will award the appropriate sanctions against us. And I would expect the court to do so if that was the case. And we don't need to get into any more of that because there is a remedy for that. That is not a basis to deny us filing a complaint for this plaintiff who is a brand new plaintiff and has nothing to do with the operating agreement. The court will
why not
also
a whole
note,
new case then, Mr. Grimm? I guess that begs it. If there is truly at least in your mind, a separate cause of action here, why within this complaint adding obviously the LLC, the corporation, as a party plaintiff, why within the bounds of this, why not file a separate action?
well, we could. And this is what we were faced with. If the court would rather us do that, that's fine. Here was our dilemma on that. We're before this court on this matter. We could have filed, and if the court directs us, that's perfectly fine to file this as a business docket case. But we wanted to start here because it is in front of Your Honor, and it is basically the same facts and the same transaction. So that's why we brought it here, and we wanted to get leave because it's been more than 14 days since their first responsive pleading. So that's where we started with this. But because it seems to me with judicial economy that we would do them both in the same case because it's this, though it's a new plaintiff and a wholly new plaintiff with wholly new causes of action for that plaintiff, it is basically the same factual development that's going to be done. And so for judicial economy, it seems like to me, all the depositions, the forensic analyses that need to be done would be done in one case. And Your Honor happens to have this case.
Well, I greatly appreciate your concern for judicial economy and efficiency. Those are things that are near and dear to my heart, I know, as along with the other my colleagues on the court here. And I guess it brings me then to my second question. Well, you know, by its nature, it's a derivative action. The LLC itself, of course, is its members. 50-50, these two parties. Why isn't it all sucked into that arbitration agreement as, you know, I anticipate the defendant's going to argue?
Well, he has pointed that out in his brief, but the operating agreement, as we discussed before, very specifically talks about a dispute among members. and that member disputes shall be, when it comes to membership interest, shall be subject to that. Now, we've already argued that, but I don't think any reading of that or any law that I'm aware of, and maybe there would be a motion at some point that Mr. Gilbertson can bring forth law that says the the LLC as a separate entity is somehow a member. Yeah, there is a provision that we've already argued talking about the membership interests. This is not that. This is the LLC bringing specific causes of action against two defendants that knowingly received converted funds. And we also have an equitable count in this complaint. This has nothing to do with membership interests. This is not a membership dispute. This is the LLC bringing its own motion through one of the members. So that,
Yeah, and I guess
yeah.
we're getting back here to something that was a long time ago for me, law school and the law of course, corporations and LLCs. But of course, that they are these artificial persons under the law, and that inherently, particularly in the case of an LLC, it is composed solely of the interests of its members. In that, the LLC. Because of its structure, acts only at the behest of the members, and exists solely for their benefit, somewhat like a traditional corporation would exist for its benefit of its owners, its shareholders. How and I guess I haven't seen either side a case or anything on the issue yet, but it just struck me that we're talking about that difficult question of labeling here, and that isn't a derivative action on behalf of the LLC in reality an action by one of its members, and therefore subject to the dispute resolution clause.
Well, no, for two reasons. One is with regard to the dispute resolution clause, the court might note in the amended complaint that we have removed the count that talked about the operating agreement. The reason we did that was because the court was concerned, and I think the court said, oh, we were trying to have our cake and eat it too with regard to alleging the applicability and the violation of the operating agreement. We have now determined, when we did the complaint, we were unaware of whether there was a signed operating agreement. The court pointed out that there wasn't one, and we have determined now through just this procedural wrangling that we've done for several months now, and there's still been no addressing of these facts and a redressing of these issues. So what we did was, since it has now been determined that there is not an operating agreement, we have removed that from the complaint, which should render the prior motion that the court has taken under advisement moot.
I see. So your argument is right. If I grant and allow amendment here, the prior will be moot because we'll no longer be an operating agreement world. Of course, we're still an LLC world, and after all, an LLC does require some sort of operating agreement. And of course, I have been presented with two in this case. One that I believe was signed by Mr. Tetzlaff as the sole member, and then a second one allegedly shortly after dividing membership 50-50, but never signed. And in thinking about this since your last appearance before me, Mr. Grimm, it occurred to me that it seems to me that both these parties operated with some degree of success under this operating agreement for a number of years anyways. There is an argument here that they certainly adopted it. Now, whether they adopted all of its terms, thereby or not, or only some of its terms, I think there's probably some room to argue about. But in any case, it appears to have functioned under the operating agreement as a going entity. And now you're saying you're going to take the position that there simply is no valid operating agreement.
Right. The court was concerned about that issue, and you said that, well, because we made these allegations in our complaint, which was the very first filing in this case, we did say there was a violation or breach of the operating agreement. Now, we have determined, as the court just mentioned, there is no signed operating agreement. And the other thing is, if the court wants to get into these are all questions of fact, by the way, Your Honor, that I think need to be resolved in our favor for the reasons we talked about last time, because all factual development must be, it's their motion, they must be resolved in our favor. So whether there was a ratification or not, at a minimum, is a question of fact that must be resolved in our favor. But I also think that there can be, if the court wants to talk about potential ratification, the question of fact here is, there was no indication, nothing alleged, nothing pled, that the parties ratified that particular portion being 12.1. And there are carve-outs on the thing. And so, again, we're talking about factual developments here, again, that must be resolved in our favor. And to say now that, well, the corporation might be a member without any briefing on that, subject to an unsigned operating agreement that the parties may or may not have ratified some portion of, it seems to me that we're really getting here into preventing the corporation, I'm sorry, the LLC, from pursuing a cause of action.
Well, and that is an important distinction that you're pointing out there, because of course a corporation, somewhat differently envisions perhaps, in terms of a traditional corporation. Well, and that's impossible to, because of course there are so many different flavors of individual corporations. I guess it might be more efficient to say an LLC is a unique flavor of a corporation that incorporates its members, somewhat like a partnership incorporates partners, in that they have this unique ability and empowerment to act, and that occurs through the operating agreement. And I guess absent an operating agreement, there's probably a question as to whether an LLC itself actually exists or not, or what structure exists here. And this was filed. I mean, there is a filing right in the state of Michigan. It says
yeah, it is. I'm sorry, I cut you off. I apologize.
yeah, no, I mean there is a filing that says this LLC exists. And then I guess
is
from
an
there
LLC.
you just presume the rest of it does, that
Yeah,
the
exactly.
operating agreement follows.
It has been properly filed as an entity, an LLC, with the state of Michigan. Now, the applicability of this operating agreement, as we've talked about, or the existence of it, needs it at a minimum. It's a factual development, and again, we've got to have that resolved in the non-movant's favor, and that's very clear. And the court rule also, as the court knows better than any of us, the request to amend, especially at this stage, when there's been no answer to the complaint at all, the court should liberally grant our request to amend the complaint. We can get into all this in this lawsuit. And the other thing is that part of our lawsuit here is that for the amended complaint is we are asking for equitable remedies too, an injunction and other equitable relief that cannot be done by arbitration. And that's only the cause of action that the LLC by itself, only the LLC can bring that, not a member.
The equitable cause, and the equitable causes that you're asking for, I guess, are the constructive trust, and of course the removal of Mr. Tetzlaff as a member and manager of the LLC. Are those actions authorized under the LLC statute?
Not to remove him as a member, but to remove him as a manager.
Yeah,
yes.
we can't bring, and I don't know what the court would do with this, but it's not for me to say, it's for you to say at some point. but only the LLC can bring a request to remove Mr. Tetzlaff as a manager. We can't, there's no authority to remove him as a member.
No, and I
But-
didn't see that under the I mean, if we, under either flavor of the operating agreement, I guess I didn't see that either.
Yeah, and we can't ask for that, but only the corporation itself can ask the court to remove him as a manager if we meet our factual burden on it. But we never get to any of these if we can't develop the factual development here and we can't get to that until the court allows this thing to proceed.
Now, and the other question I did have is I didn't see any limitation. I mean, if I did say no, absolutely this, if I, because one thing that occurs to me is, well, we didn't have the 50-50 operating agreement, but we did have the 100% to Tetzlaff operating agreement that he signed at some point. Well, if I put it on, and I think that the dispute resolution clause is the same under both. If I jam it under either, why couldn't the dispute resolution mechanism grant equitable relief? I didn't see any limitation on it.
There is limitation because the 12.1 specifically says when there's a dispute among members regarding membership interest, and it talks about any decision by this CPA and the other two by, I guess, a majority is binding on the membership interests. There's no provision in there that that it can grant equitable. It doesn't have equitable powers. It's only binding on the dispute that they're having. And again, we're talking.
Well, certainly the involvement of the CPA, it leads one perhaps to the conclusion that everything that they're going to decide would be some sort of financial resolution, but I don't see anything in there. It does say this is a dispute between the parties holding membership interest in the company, but if that dispute involves removal of a manager, I don't see any limitation that mechanism couldn't do that.
I don't know if this is, again, a factual development that's got to be resolved in our favor. And again, I will get back to the LLC is a separate entity sanctioned by the state of Michigan and developed and formed under the laws of the state of Michigan. It is a separate entity. It is not a member subject to whatever this is. And as I said,
no, I get I'm struggling to remove the LLC from its members. Like it would be equivalent of saying a partnership. Well, Judge, this partnership is not its members. There's a separate, a law firm, an LLP partnership. Well, of course, it does exist. It is an entity that exists, but to say that it exists separate from the financial interests and management interests of its members is seems to me a very tough argument.
well,
We can brief that because there is case law on that.
Look, here's the thing. We are trying to decide these things right now without any briefing, without any factual development. And frankly, Your Honor, what they are asking for here is wrong.
Sure. Well,
this
and
guy-
by its nature, I need to decide everything here on a legal basis, right? We have to assume every factual basis is going to inure to your benefit because the motion to dismiss asks me to do that on what I would say a purely legal or jurisdictional basis here. You're challenging that based on the LLC's individual rights, as a separate entity from its members. You're correct. I haven't seen any law, and I haven't kept up with the LLC law, as well as I'm sure Judge Yates and other legal geniuses have to know, what the current status of it is vis-a-vis the members. I know that, corporations, that's been an ongoing question that the case law has addressed. So, well, and I may wind up asking for some supplemental briefing on that, but let me hear from Mr. Gilbertson first. Perhaps he has an answer that can cut quickly to the core of the issue here.
Well, thank you, Your Honor. And I'll start with where you had mentioned, which is, okay, if this last operating agreement is somehow invalid, then we go back to the last valid version, right? If there's a new will that purports to destroy every prior copy of the will, but then it turns out that that will itself was invalid, so was its rescission of the prior wills. And you go back to the last valid version. So I'm not quite sure the argument that they're making that, because there's an unsigned copy, then somehow
Yeah, the
should
50-50
never.
copy's invalid. Then we, one argument certainly would be, well, we revert to the signed copy, which, predated the unsigned copy. And I guess that, brings me to another question is that, I think everyone agrees that the LLC was filed with the state of Michigan back at the date of its formation around 2018. Does the, and you may not know this off the top of your head either, but when you file that with the state of Michigan and it's filed, does it carry with it any legal presumption that a valid operating agreement exists, or that the other corporate formalities, I mean, I guess I'm likening it to a C Corp, and of course we all know those require a board of directors and minutes of their meetings and et cetera, much of which is not filed with the state of Michigan. The filing may just be, hey, I'm out here, I'm a corporation, and here's my resident agent.
Right.
What does the LLC statute envision after
Right.
it's filed?
Correct. The LLC statute only needs the articles to be filed with the state to gain endorsement from the state. There is no requirement for an operating agreement in order for it to be a valid LLC. The real issue comes to, will there be corporate protection, which is the purpose of the limited liability company, right? Are you running this like a company, or is this your alter ego? So that doesn't affect the validity of the entity. That affects the court's analysis of whether a veil piercing occurs. But no, there was an operating agreement that was valid in this case. And I do want to point out again, opposing counsel in the last hearing argued that they had a copy of the unsigned operating agreement. Well, how did they get a copy of this agreement? And at no point did they allege, and this is when they're filing the action, at no point did they allege that there's something different in this version than the one that they thought was appropriate. They thought we had a signed copy. Turns out that we can't find a signed copy, but their assumption was that that was the document, right? So if there was a ratification agreement, I'm aware of no case law out there, they certainly haven't cited something, that now they can go back retroactively and choose whether individual clauses of an operating agreement were ratified or not. Well, we now don't agree to this one, but we do agree to the one that says that we have member control and says that we can prosecute after our claim. I mean, you can't cherry pick the operating agreement. Either it exists or it doesn't. If it doesn't exist, then they don't have membership interest in the company. Here's the real issue. I reminded opposing counsel of this during our last hearing as well, so I'm a little surprised to have to point back to this. They focused solely on 12.1. Oh, it's membership disputes. Member. No, it's also managers as well. 7.3. Dispute resolutions relating to the above acts within Section 7, which is manager rights and duties, shall be governed by Article 12.1, which is the same arbitration provision. So you say, well, what type of manager limitations were contemplated should be sent to this arbitration panel? Well, Section 7.3, talking about any act taken or sum expended or decision made by any manager on behalf of the company. They're alleging that Mr. Tetzlaff made a decision to issue a company card or to approve company funds to his daughter, Liberty, who's an employee. They're alleging that was an abuse of his discretion as a manager. That's squarely within 7.3, which says that it needs to be settled in arbitration. So Your Honor's correct. This should be a global matter that is resolved at arbitration, because at the end of the day, if John authorized Liberty to incur expenses, that's a manager dispute. That does not have anything to do with Liberty. No one's argued that Liberty is making unauthorized purchases without the consent of John in this situation. So this all goes straight back to a manager dispute, whether John was authorizing purchases or whether he should have controlled the company card, etc. Liberty's a 22-year-old girl. This whole issue, you know, Your Honor, you haven't seen our defense, obviously, at this point. We haven't even filed an answer. So this whole
And
issue is very one-sided. But here's the real nuts and bolts of it. John was utilizing the company card as an owner. He has owner draws. He was, you know, utilizing certain expenditures for the company that they think were personal. There were other ones that were basically equitable offsets for what was being paid to Katie and her husband, who was unexpectedly hired. There's a whole backstory there, and we can get to that. But at the end of the day, they are arguing that he abused his authority as a manager by issuing a card to Liberty and allowing her to incur certain expenses. This should all be handled under the arbitration agreement. I'll note as well, I'm sorry, Your Honor,
Yeah, no, you can continue.
okay. There's no limitation on the equitable powers in the arbitration. I'll note the arbitration clause contemplates a 30-day procedure, right? So this is, when you talk about equity and injunctive relief and all of that, there's supposed to be the dispute settled within 30 days and then the creation of a panel. We've said for the last 5 months, 4 months, let's create the panel. Let's proceed forward. Let's solve this problem. They didn't want to do this. The second part of our motion, or our objection to their motion for leave to amend, was that this was harassing Liberty and harassing John. That the only reason here was to unduly delay, embarrass, and increase expense. Well, certainly from an increased expense, the fact that we're here arguing before Your Honor has had an opportunity to rule on the arbitration provision is just increasing the expense for everyone. But here's the real issue on harassment. My client has said, I will meet and provide every single account statement, credit card statement, bank record, whatever you want to see, I will provide that to you. Let's sit down and let's mediate this.
Sure.
Hold
And
off
that
on the
would be the
litigation.
accounting, I think, that's asked for there. And obviously, if a CPA was part of that, they could give at least weigh in on their review of the statements submitted as to at least their completeness. You know, it's not obviously going to be a full-on audit or anything like that, but I guess that's probably why you include a CPA in that discussion, is because they have the ability to at least quickly dissect what the numbers look like when they're provided with the relevant paperwork. So,
Correct.
yeah.
And we're willing to do that. We've proposed to do that. We've asked to do that. Within the next 60 days, we will meet, show you all of the records we have. We don't think we've done anything wrong. To the extent that there are expenses that you've got concerns about, let's solve the issue here. Let's have a resolution, because the company's in deadlock. What's happened now, and the reason why this arbitration provision exists, one of the very good reasons, is so that the company's dirty laundry isn't aired for everyone to see. And what's happened now is not only has John been accused of outrageous things that should have been handled privately in arbitration, but now his daughter, who's also an employee at the company, is being accused of misspending $100,000 of company funds. You've got an administrator that is now hostile to them. So now John can't even work or really get anything done at his own place of business. Now they're trying to do the same thing to his daughter. That's why the arbitration provision should be holistic and handle things privately as intended by the operating agreement.
May I,
Okay.
Your Honor?
Yep, you may weigh in again.
Because I've had a belly full of this. Because first of all, Liberty is not an employee of the company. Okay, let's just get that straight.
Well, she
Number
doesn't
two-
have to be, though. She could be an agent or, you know, I
You
mean,
just said-
he can retain her under a whole variety of auspices. She doesn't have to be a, you know, that she's working and clocking in 40 hours a day, right? I mean, as
You
a,
just said she's an employee.
well,
That's what he
yeah, I
said.
get it, but I think what
Yeah.
he's really saying is, well, Teslaff authorized her to utilize the card as a contractor, agent, employee, something
Oh,
of the
whatever,
company
you know.
under his blanket authority. I don't think he was arguing in the stricture that right, she was clocking in 40
I don't
hours.
know. I always just take attorneys by what they say, not what they mean. Probably a
No, I
interpret that.
I
The same way with
understand where you're
courts,
coming from.
But these are all factual developments here. And Liberty, for example, we have alleged, and in our complaint, those allegations must be taken as true, that she received converted funds. And therefore, we are entitled to treble damages. Now, these are, again, we keep talking about all these factual developments that, oh, maybe he didn't do this, and maybe he meant to do this, and oh, this dirty laundry, we want a private, all this and everything. This corporation has this LLC has an absolute right independently to bring this derivative action against this manager, period. And again, the court rule provides that it should be liberally allowed us to amend our complaint. And we have presented that to the court, and I don't know, I mean, I don't know if you, I don't know. I don't know why we can't get this case in front of a court. I swear to God, we've been so long here without an answer to the complaint, hiding behind some fictitious, potentially fictitious LLC operating agreement that may have been signed, maybe not signed. These are all questions of fact, and I beg the court to please follow the law, interpret these things in our favor. Let's get to this, and if there is a factual development here, then we'll live with it. Period.
Well, what about
Briefly, Your Honor?
his idea of the reversion of it, which makes logical sense to me. I've been presented with two versions of the operating agreement, one signed by Mr. Tetzlaff and the other unsigned.
When was it
If I'm
signed?
told the unsigned one is no good, then why? And I mean, of note also is the fact that with the exception of the 50-50 division, the provisions of the operating agreements are virtually identical in terms of the management and importantly the dispute resolution provisions here. Why wouldn't I revert to the signed one?
Well, because is there a date on it?
I think
Is
the
there a
signed
date
one
on
is
it?
dated, although I don't have that.
It's
well,
not.
I do have it here.
All right. And here's the other thing, Your Honor. This is why this smacks to me of potential fraud here too. We've got an unsigned membership agreement that says he's the sole member. Then why do you have these why is it identical in every other respect? Why do you have member dispute resolutions if he's the only member? There are all kinds
Same
of
reason.
questions.
The
Yeah,
same,
Oh, he's gonna
suppose,
disagree with
yeah.
himself?
Yeah, that he
Okay.
would contemplate perhaps that he could bring in another member. And although I
Correct.
think he does say if you bring in another member
Okay.
or you split at least the ownership interest, they don't necessarily have managerial interests, but
Well, why is Katie a
I'm not
manager
that
then?
familiar.
It's undisputed that Katie is a manager. Katie Juarez is a manager. That's undisputed.
Your Honor, if I
Well, and
may.
I guess you're right. That being undisputed, then goes to well, that must mean then they ratified the second operating agreement, even though it was unsigned. And ergo, the question is, do you have to live with all the terms of it?
Exactly. There's a question. You said it. There is a question, and that question must be resolved in our favor.
Your Honor, if I may.
Yeah, I did have one more question for Mr. Grimm, and that was, I did note in reading through this again that paragraph 7.2, powers of managers does allow an individual manager to commence, prosecute, or defend a proceeding in the company's name. How does that interrelate with that statutory provision you're invoking for the company to bring suit in this instance?
Go ahead. Ben will answer that one if it's okay.
Yeah, that's
So
fine.
So yes, the operating agreement says that, but let's say we would have filed on behalf of the LLC from the beginning. John Tetzlaff would have had just as much right to file for the dismissal of that case.
Because they were 50-50.
That's why we get into the derivative nature where we're taking that ability away from him. And it actually is giving the court a lot more authority as far as making sure that this case is resolved properly.
Yeah.
Yeah, I see. Although I do also see a potential, could turn into a messy counterclaim if Mr. Tetzlaff then says, well, I'm going to bring the counterclaim with resolved to the Legacies LLC versus the Legacy, and then we're going to have everyone on both sides of this thing creating a royal imbroglio out there among the parties.
And it certainly will, because that is our next step. But we're trying to resolve this efficiently. And we propose, let's just meet at mediation and figure this out. Even while the court's trying to figure out the arbitration applicability, let's just get this done. Let's accelerate discovery, right? Right now, no party can take discovery. We're willing to provide the documents right now. We've got nothing to hide. We want to address it. We want to figure out how to move forward with the company so that we don't have this untenable situation. But here's what's quite frustrating to me. So number one, opposing counsel is opining on things he simply doesn't know about. The operating agreement, the first one, is a signed and dated copy that was an exhibit to our complaint, is dated March 1st, 2018, signed by John Tetzlaff. So there is a signed,
that.
there's a signed version. This was an exhibit attached to our motion for summary disposition. The date of that motion for summary disposition is 7/7/2025. This is exhibit 1, so review your records. Secondly, in the law and argument of that same provision here, because we've heard him beg you to follow the law. Well, he's using one aspect of the law, which is true. The normal standard on motions for summary disposition have to be construed in his favor. But what he's wanting you to ignore is this. I've already quoted this in other hearings, Altabelli v. Hartman. The burden is on the party seeking to avoid an arbitration agreement, not the party seeking to enforce the agreement. So respectfully, it's his burden to show why this operating agreement, which allegedly he now says doesn't even exist as a valid document, would not control the parties, even though the parties have abided by it. If he's going to say that it's not valid, then Mr. Tetzlaff would be the sole member and his client has no reason or action to bring a derivative claim.
If we revert to the only valid one being the March 1st operating agreement that he signed solely, right, obviously he's the sole member and manager, and then we don't have much of a dispute among members. So, right, I think, unavoidably, it goes back to the same issue we argued about before, in that does, a company abiding by an operating agreement ratify it, and does it ratify, therefore, all of the terms of it, even if unsigned, in this instance. And, it would certainly seem to me that, some case law on ratification of contractual terms might be relevant here. What I will do, I'm going to take this under advisement along with the one I've already got under advisement, which I'm already working on an answer. I'll invite the parties to file any additional briefing on the issue of ratification of an unsigned operating agreement and or contract in general. I think LLCs may be new enough that, there's not a ton of case law out there on, the impact of an unsigned operating agreement. However, having at one time been a commercial litigator, I know there's ample case law on the application of unsigned contracts and parties abiding or ratifying them by adoption of their course of business and course of dealing with each other going forward. And it would seem to me here that, given we did have at least one signed version of this operating agreement, and then another one that installed Ms. Juarez as a member, and that her action here, is to essentially enforce her rights as they're conferred on her as a member and a manager here, that, whether we say, it's de facto or de jure, and that's for me to decide. And I guess the defense motion is it's de jure, judge. We wrote it down, and this is the way it goes. And of course, the law does favor the stuff we write down, whether we make the private law or the public law of the state of Michigan. The law tends to enforce writings between equally informed and situated parties. And so, I guess from where I sit, there is, a pretty darn good, and, just part of that is the practical nature of it, in that this thing was operating, at least beginning in 2018, taking care of people like it was envisioned to do. It appears to me that, this division of power of the managers was in place. Of course, they didn't invoke the dispute resolution, but perhaps no dispute bubbled to the surface until this matter became an issue between the parties, in more recent history, which would, just tend to indicate to me that the parties did indeed ratify the operating agreement and were acting in every way as if it was valid, raising the question of then, Judge, why chop out the one the dispute resolution provision. And, to Mr. Grimm's credit, he made those arguments, I think, in a credible way, as to why I shouldn't enforce the operating agreement in the last argument and set of briefings that we had. And I will review those as well, obviously, as I'm formulating my opinion and order on both of these matters, but I would invite the parties, if there's anything on ratification of by conduct of contract that you'd like to cite to me, just submit the supplemental briefing within the next 7 days, so as not to hold up my resolution of this thing any longer than I already have. I do appreciate the parties' desire to get this resolved, and I don't want to be too much of a roadblock because of the fascinating legal questions raised here and my own admitted rustiness on the law of limited license corporations in Michigan. So I'd invite that supplemental briefing. Don't make it a whole rebrief of all the prior issues, just the ratification issue. And then after that, I will issue a written opinion in order.
Your Honor, in the interim, could you ask Mr. Gilbertson if he would agree that both managers will not expend any money without the consent of the other so that we can stop this bleeding?
Well, I don't know. Mr. Gilbertson, what are your thoughts?
Your Honor, right now what is happening is they've effectively ousted my client from being able to do anything. He can't terminate an employee. That was the ruling.
Right, I already ruled on that. Yeah.
Right. And so because of that, he's got, frankly, insubordinate employees that refuse to do anything to help him or even listen to him. They've taken the other manager's side because of this issue. So no, he sees no ability in the interim here to work together with her. We have said we will provide everything you want in terms of meeting for a mediation within the next 60 days. We'll give you full access to QuickBooks, to accounting, all of that sort of thing. But let's stop the bleeding in this litigation, and they're refusing to do that. So they're making an opportunistic ploy here to make it look like we're being unreasonable when the reality is quite different.
Well, and
We just want him to stop. We just want him to stop stealing. That's all.
Well,
It's
and here's the
ridiculous.
thing is, as it occurs to me, when what would make push come to shove in this matter would be LLC's not paying its rent, gosh, I'm already forgetting the name of the entity here.
Legacies.
Yeah, the Legacies isn't paying its rent, and we got these, memory care patients being wheeled and stumbling out onto Forest Hills Avenue or wherever this is out there, and no place to go. And that mismanagement is resulting in the failure to operate of the Legacies to the detriment of the people living there. I haven't seen that yet. What happens, and how the finances there are therefore sliced and diced is a part and parcel, of course, of the lawsuit itself. So I'm hesitant to impose any condition. I certainly would say that, the parties do see any value in meeting together or having council meet together and hash out even an interim budgetary cycle to cover the next 60 days or whatever. Well, at least this is pending and to be resolved by me, and then ultimately either whether it proceeds in front of me or proceeds pursuant to the dispute resolution clause. Right, neither of those are going to necessarily happen next week. In fact, they won't happen. My opinion won't be out next week because I'm going to let you brief it for another week. So, given all that, I would say that I'd invite the parties if they can come to a agreed upon distribution. But my only concern would be, from a practical standpoint, we shouldn't have, as I said, Alzheimer's patients, freed to the cut loose and sent to the winds out there. And I frankly think, probably both sides here, even though they're disagreeing with each other and the way that funds are expended, probably agree that an operating concern, one that's taking care of patients and doing what it's supposed to do, is ultimately in their both best interests. And the fundamental dispute is, how the underlying finances are run here. So, but if you can come to an agreement on that, it'd have to be a mutual agreement between the two of you. I'm not going to weigh in or order it. From my perspective, that would be overreaching for where we are.
Thank you, Your Honor.
That's kind of why we need to get this going in front of you. Thank you, Your Honor.
All right. Thanks, gents.
Bye-bye.